For the purpose of present discussion, the most important provision is contained in Article 51C. Noted above, it is however significant to note that this article specially mentions international law and treaty obligations. It seems somewhat paradoxical that separate mention should be made of treaty obligations as they undoubtedly constitute integral part of international law. No explanation is to be found in the Constituent Assembly debates either as to intent of Article 51 or the meaning and scope of the treaty, international law and treaty obligations. Professor C. Z. Zagratovic says that the expression international law in this paragraph connotes customary international law and that treaty obligations stand for treaties. This interpretation would seem to be the most logical in the context of the article as well as of attitude of the Indian courts to questions of international law. But Article 51 does not give any clear guidance regarding the position of international law in India, as well as the relationship of municipal law and international law, because this article is contained in Part 4 of the Constitution of India. Part 4 of the Constitution deals with the directive principle of state policy. Article 37 of this part clearly provides that the provisions contained in this part shall not be enforceable by any court. This article, Article 51, falls in the chapter on directive principles of state policy which are non-justiciable. Secondly, it is doubtful if the expression state includes the courts also within its ambit and if the directive principles have been addressed to them too. However, it would be wrong to contend that Article 51 is of no relevance and provides no guidance at all. Article 37, which provides that provisions contained in Part 4 of the Constitution are non-justiciable and in unmistakable terms that the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. The majority of constitutional experts in the country now subscribe to the view that simply because the principles contained in Part 3 are non-justiciable, it cannot be successfully contended that they are of no significance or even of less significance than the fundamental rights contained in Part 4, which are justiciable. Amendments of the Constitution, particularly 24 and 25 amendments, confirm this view as noted above. The term international law in Article 51 refers to international customary law. It is thus significant to note that both international customary law and treaty law have been treated on the same footing in Article 51. It may also be noted here that an analysis of judicial decisions shows that in India wisdom is followed. Nevertheless, a pertinent question arises as to whether the Constitution of India has altered the position prevailing in the Constitution period. In this connection, Article 372(1) clearly provides, notwithstanding the reading by the Constitution of the enactments referred to in Article 395 are subject to other provisions of the Constitution. All the laws in force in the territory of India immediately before the commencement of this Constitution shall continue in force in the in force therein before until altered or repealed or amended by a competent legislature or other competent authority. Before the adoption of the Constitution of India, the British practiced that customary rules of international law are part of the law we then applied in India, so this practice continued even after the adoption of the Constitution by virtue of the provisions of Article 372 until it was altered or repealed or amended by the competent legislature or other competent authority. As therefore been aptly remarked, it does not mean that the laws of Indian courts are entirely closed to the wide absorption of its. The Constitution of India did not alter that position, for it provided for the continued operation of the law in force immediately preceding the commencement of the Constitution. Therefore, on the analogy of the English common law, the municipal courts of India have applied the provisions of the treaties entered into by India. If they have been incorporated into municipal law through legislation and the well-recognized principles of international customary law have been applied because they are supposed to form part of the law of the land, it is thus the dubious view of international law which has been commenced by the institution Indian courts, which that international law can become a part of municipal law only by specific incorporation. Thus, Article 51 of the Constitution of India, insofar as it requires the various organs of state to foster respect for international law and treaties, would seem to strengthen rather than weaken the legacy of the common law principle that international law will be part of the law of the land. This is so, notwithstanding the precise formulation of Article 51 and Constitutional Declaration in India are not mere embellishments on paper, they reflect law in action. Thus, so far as customary rules of international law are concerned, the position prevailing immediately preceding the commencement of the Constitution continued even after the coming into force of the Constitution. In India also, customary rules of international law are part of the municipal law, provided that they are not inconsistent with any legislative enactment of the provisions of the Constitution of India. As regards the treaty rules also, India follows more or less the British jurist view. This is, that is to say, ordinarily international law can become part of municipal law of India if it has been specifically incorporated. Instead of Madras versus Hindi Menon, the Supreme Court held the Indian Extradition Act 1903 has been adopted, but the Fugitive Offenders Act of the British Parliament has been left severely alone. The provisions of the Act could only be made applicable to India by incorporating them with the appropriate changes into an Act of Indian Parliament and enacting on Indian Fugitive Offenders Act. In the absence of any legislation on these lines, it seems difficult to hold that sections of the Fugitive Offenders Act have force in India by the reasons of the provisions of Article 372 of the Constitution. In this case, Mr. and Mrs. Menon were advocates in Singapore. Then a British colony, Mrs. Menon had also served as a member of the Legislative Council of Singapore. They came to India in July 1952. The Colonial Secretary of Singapore requested the Government of India for their extradition, for there were certain changes against them according to the law of Singapore. Rejecting the request for their extradition, the Supreme Court held the whole basis for the applicability of Part 2 of the Fugitive Offenders Act as gone. India is no longer a British possession, no order in council can be made to group it with other British possessions. Those of the countries which still form part of British possessions established along with British India were put into a group which ultimately declined to reciprocate with India in the and of surrender of his offenders on the ground that, notwithstanding Article 372 of our Constitution, India was no longer a British possession and therefore the Fugitive Offenders Act 1881 did not apply to India and they were not bound in the sense of a new treaty to surrender their nationals who may have committed extraditable offences in the territory of India. The Supreme Court therefore concluded, in these circumstances it is not possible to work out the sections of the Fugitive Offenders Act and apply them to the situation that has arisen after the coming into force of the Constitution of India. वित्त मंत्री निर्मला सीतारमण बजट लोकसभा में आज औद्योगिक संशोधन विधेयक आज का केंद्रीय मंत्री डॉक्टर मनसुख पेश करेंगे बिल का प्रस्ताव।